Abhijit, what do you make of the decision by the court to not go into personal laws? Is it just, deflecting a complex issue that arises out of legalization of same-sex marriages for a later day and deferring it as the court almost accepted?
Look, I don't know what their personal motivations are. It's probably to, follow a path of least resistance or whatever. My petition is for the Hindu law specifically. It isn't under the Special Marriage Act.
Yeah.
Because if you read the Hindu Marriage Act, it says husband and wife. It doesn't say man and woman. So very clear it refers to gender roles and not to genders, to marriage roles and not to genders. Right. Now, as for why the court does things, this is very much Ram Bharose. Nobody really knows why the court does what it does. It works in mysterious ways.
But do you believe that we fundamentally cannot move on as a society unless we do grapple with the concept of personal laws? Because fundamentally, there may be individuals who want to get married amongst the LGBT community as ordained by their religions. That may be a desire.
Right. So, see, the thing basically comes down to, first of all, this argument that somehow marriage laws, personal laws included, are necessary for, are meant for the purposes of procreation, that marriage is meant for procreation. I mean, really? I mean, can you not procreate without marriage? I mean, does marriage confer a certain fertility on you that you suddenly get fertile and can give birth to babies after the Marriage Act and can't do it outside of marriage? Rubbish, right? A marriage is any law, including a personal law, is basically a contract. It's a contractual law. And the point of entering into that contract is once you enter contract, as per contract law, you have certain responsibilities, certain obligations, certain privileges, and certain liabilities. Right. It is to formalize that entire system because a lot of things in this country, like financial inclusivity, depend, where married couples can get certain privileges, work privileges, loan privileges, bank privileges, etc., etc., etc. It is tied into a whole load of things like financial inclusivity, child protection, etc., etc., etc. So you fundamentally need that to extend into all laws, not just a separate standalone as in the Special Marriage Act.
But can I understand from you, is it essential for petitioners like yourself to be allowed to the right to, in your case would be child rearing, so I'm guessing adoption, but let's say in the case of a lesbian couple, childbearing as well. Is that essential, or are you fundamentally only looking at certain benefits, economical and otherwise, that come with being recognized as a married couple?
See, it has to do with the protection of the child. Because you tell me, how does inheritance work otherwise? Assume you're born into a family with the Hindu Marriage Act and you then get married under the Special Marriage Act. What inheritance law then applies to that child? We already have a whole gamut of cases. If you go to the family courts that have arisen, inheritance cases and things like that have come about precisely because of this conundrum.
No, but
right, the children who get adopted need to have that security. So it's not just benefits. Understand, benefits, economic benefits is one thing. Security is a completely different thing.
I'm asking you this question because the court, you're taking it for granted that obviously this will lead to certain rights about childbearing and child rearing. But I'm asking you this question because it almost seems like the court is skirting that question. For now, they're only looking at quote-unquote legalization of this union. They're not even going into whether they will be later allowed to have kids, adopt kids, bear kids, etc. That is fundamentally what I'm trying to understand from you. Would you have rather the court went into all of this than skirt this for now?
Look, the issue in front of the court is very, very simple, right? It's a question of equality. Bas. These are questions, the questions that you are asking, Shivani, are for the rest of society to sort out and for the government to see to it that there's a synthesis of the laws once it has been ratified by the courts. Okay. All they have to decide on is marriage equality required at this time, and is it feasible to be given at this time? Bas, nothing more.
Okay. Shashank Shekhar Jha, I want to understand from you, SG Tushar Mehta did make this point that, even under the Special Marriage Act, there is a clear distinction that marriage is a union between male and female. I'll get into that whole discussion of what transpired because of that comment. But what do you make of the fact that the courts are now saying, okay, let's just look into Special Marriages Act. It is the easiest thing to do for us. It can be easily made gender neutral and will not touch personal laws, because clearly that's a fire pit that even the Supreme Court doesn't seem to want to get into.
Namaste Shivani ji and every other fellow panelist. Shivani ji, first of all, before going to your question, we need to understand that according to Hindu Marriage Act and Hindu laws, marriage is not a civil contract, but it is a sacrament.
Yes.
It is not merely a rituals, but an entire institution, and that is why we have separate legislation for the same, and it has been the objective of the parliament altogether. Now coming to your second question, see, Supreme Court has clearly stated that it will not interfere the personal laws, because as far as society is concerned, we have not come to that stage where we are even ready for the UCC. So when there is no UCC, you cannot expect that one community will be transferred and other will not. Now coming to the Special Marriage Act, see, we need to understand the objective of Special Marriage Act. I will just quote you section 21 of the Special Marriage Act, just one provision, and you will know that the objective of Special Marriage Act was always for heterosexual community. You cannot expect now that judiciary should interpret it in such a way that it will transfer or change the nature of the Special Marriage Act. And if it does so, then what will happen to other laws which will be affected by this? See, we need to understand that in India, currently, the marriage for women is 18, the age for marriage for men is 21. So how will you differentiate? How will you take that? If you will take 21 or 18, because according to special it is 21 at a few places, but then there are other laws, for example, inheritance. How will you do with adoption? How will you do with other property rights, etc.? So I guess I don't think that without listening to, see, one thing is that Supreme Court should not entertain this petition in the first place. This is a case of completely misguided intentions, and the priorities are not straight. But even if Supreme Court is entertaining this, I don't think how they are doing it without even listening to the states and union territories. Remember, marriage rights are completely under the duty of both state and center as per constitution. So if there is a talk about constitutional morality, you need to follow the constitution. According to constitution, this falls under the concurrent list, which means both state and center will have to abide by it, or you will have to hear both the sides.
No,
Suppose
on that,
Supreme Court passes an
I get
order
your point.
and says,
no, I get your point, but on that, I don't think the Supreme Court has refused that they will not allow the states to be party. Let's give it time. But on personal laws, they have almost said that they're not going to go into personal laws. So let me just stick to that. And I take your point that, of course, this is on the concurrent list. The states will have to be made party.